Thank you, everybody, and good afternoon. We have a lot to cover, so I'm going to begin with slide 3. And just as a general matter related to slide 3, we'll talk about a couple of these items. We're going to start off with probate versus administration proceedings. Oftentimes gathering the information, it's very similar to the other. And I have a couple of attachments that I actually sent in the course material. My course material consisted of a probate proceeding checklist, which is really helpful, and I've used it and still continue to use it. And the administration proceeding checklist is also very helpful for the same reasons. It provides you a guide about what you need to do in relation to the petition itself and the documents you need to gather and some of the issues that you need to address, perhaps. The other one was an inventory of assets with a firearms inventory in the event that you check off that there were firearms in the house of the decedent, the person who died. And also there is a citation related to the inventory that was provided, and also there was some case law which I'm going to discuss during this presentation. So as an initial matter, you need to gather information from your client who's going to be either the proponent of, the will to admit it to probate if there's a will, or if there's no will, who's going to seek administration of the estate of the deceased. And we'll get to those items and stuff, but briefly going over the probate administration checklist first before that. Under SCPA 1002, that's going to be your guidance if there's no will about who can file a petition for appointment as administrator. And that's helpful guidance. And the same is if there's a will, SCPA 1412. Normally there's an executor named in the will and possibly a successor executor. But what happens if, they're both deceased? Or somebody else steps forward and the executor wants to renounce. So that's helpful reading. There's also SCPA 205 that relates to the jurisdiction of the surrogate's court. And the surrogate's court in New York has jurisdiction over the estate of any deceased who was a domiciliary of the state of New York at the time of death. And it also includes, matters such as disappearance or interment, but we're talking about, death to make it simple. The proper venue is very similar. The proper venue for filing the petition, whether it be administration or probate, is going to be the county in which the decedent was domiciled at the time of death. So the probate proceeding checklist, we can't go over everything here, and it's really self-explanatory, much of it. But a couple of items to point out. If it involves an attorney who is also the sole executor, there's certain disclosures related to that, including the attorney executor commissions, which is noted. A couple of other things of note, too, is, in gathering some of the information related to the will and so forth, you'll be gathering the death certificate. Certified death certificate is required to be filed with the surrogate's court. So that needs to be obtained, and death certificates also need to be copies and stuff that the proponent, once letters are issued, would use in the event that somebody such as, a bank or anything requested a death certificate. These days, I don't think they're as important as they were before, but they are necessary if they're requested. So usually getting a couple of copies and the certified death certificate, but also making sure that the death certificate information is correct. I've been confronted with this information before, because if the address of the decedent is different than the actual address at the time of death, that needs to be either corrected, or there needs to be an affidavit of proof of domicile by somebody who's not interested in the estate, who's not the proponent of the will. Also, if there's any codicil or prior will, that also needs to be gathered as well. And if the death certificate shows a different name, there also might be an affidavit of heirship in the event that the will, the decedent was not survived by a distributee or only one distributee. And I've had that happen as well. With one distributee, an affidavit of heirship was required to be submitted. And again, that was by a person who is not the proponent seeking letters of administration in that instance, or somebody interested in the estate. What's also good too is the issuance of whether a notice of probate will be required. You'll see that in the description and reviewing when that is required and when it's not. Also, if the will, and this will be the first thing that's requested, of course, the first of many items. If the will names a charity, then a notice of probate will have to be submitted to the AG's office. Also, sometimes it requires the estate be registered with the AG's office, and there's certain exemptions for that related to that, which need to be checked out. And it has a fee schedule because at some point you're going to have to, value the estate, and the amount of the fee that's paid when the petition is filed is going to be dependent upon what the value of the estate is. And they have certain questions in the petition in which you'll know what the value is and enter it. And it's also on the partial fee schedule, which is in the checklist. And then there's some comments and court notes about different forms that, are always required versus forms that are sometimes required. Every estate is different, whether it's an administration or a probate, depending upon the circumstances. And with respect to the administration proceeding checklist, is the petitioner eligible to act and qualify? You look under SCPA 1001 for purposes of determining that. And you might need a renunciation if there's a co-executor in the will. If that co-executor is not going to seek it, letters, but the other co-executor you represent is going to seek letters, then you need to obtain a renunciation of those letters from the co-executor that is not going to be seeking letters. And that can also happen in an administration when there is no will, again, based upon the application of the SCPA. Also, it requires a certified copy of the death certificate, and many of the items gathered are really, the same and are self-explanatory. And I find these checklists very helpful. And it also goes through the comments of, forms always required and forms that are sometimes required depending upon the circumstances. Now, one thing that happens is in the probate of a will, if you're provided with a copy, you need to ask the client for, to determine whether they can get it original, because to probate the will after the petition is filed, you have 2 days. It's a very short time period to submit the original will to the court. And sometimes explaining to the client, depending upon how sophisticated they are, familiar with everything. I've had clients before where they think the original will is really a copy of the original, and it's not, explaining that it is the actual original. If you can't find it, there's other things that you can do, but one of the first things you want to do is look at the supervising attorney information, if there is a supervising attorney, and there usually is, and contacting that attorney to obtain the original will from the will safe or wherever they store it, because they can provide that to you. The other, I had kind of like a laundry list to go to, but of course the original will we went through, the death certificates we went through. Also obtaining other information, not only for the petition itself, but for after letters are issued, is really, and getting familiarized with the estate and the circumstances related to the particular decedent should be asked for upfront, as soon as possible. One of them being a homeowner's insurance policy, because sometimes they reveal other assets that are unknown, but obtaining, information related to the decedent's assets from the proponent, if the proponent knows of that, or from the family manners. Also obtaining, a home search for other codicils, trusts, prior wills, and again, contacting the attorney who did the estate planning related to that. Contents of personal property. At some point, the inventory is required to be filed. It's within 9 months of the date letters are issued that an inventory will be required to be filed with the court, or the court could revoke letters, and they're pretty strict about it. So obtaining this information will be helpful and useful for that purpose, because they will ask for this information, including, estimated values. Getting a copy of the funeral bill, or a waiver from the funeral director that there was no payment made, so that can be filed with the surrogate's court as well. Deeds for property, whether there were any mortgages, really important, and if there were mortgages, whether they were satisfied, and what the status is, whether there was any life estate, if there's a surviving spouse, determining, who that spouse is, and whether there's also, someone who is who was formally married, but they were divorced, because sometimes the surrogate's court will ask for the divorce decree to be submitted, depending, again, on the circumstances. And there's too many circumstances to go into during an hour CLE, so we'll forego that and just kind of go through our list here. In obtaining, other information related to family members is also good, both family members that are named in the will, obviously, for the obvious reason, and also, if there's no will, distributees and so forth related to those family members, and their contact information as well. This information is important because, of course, at some point there's going to be a family tree that's going to be filed with the court. Sometimes it's immediately right after the petition. Sometimes the court will request it sooner, but it will be required. All right. The home also needs to be secured properly, and somebody needs to be designated to, be able to secure that home, make sure it's insured, and so forth. So if something happens. And we've all heard about these horror stories that have gone on in the news about squatters and so forth, and the difficulty of removing them, and the change in the law. We don't know how that's going to play out, but it's better safe than sorry to be diligent on this. Also, is although the requirement to notify creditors of the estate was, repealed in New York, it's still important to determine whether there's potential creditors out there, not only related to maybe a mortgage that's outstanding and unpaid, what that amount is, but, sometimes the proponent, and I'm talking mostly about wills, but it happens in administration too. A family member will get notices from, banks and so forth about account balances that are due related to credit cards, and those all need to be documented and so forth. And we need to determine whether there's any judgments or lawsuits out there, determine what happened, because sometimes, unfortunately, you find out that the debts exceed the value of the assets in the estate, or they come pretty close to it, and something needs to be done. Property needs to be sold in order to pay off legitimate creditors, of which not only have filed claims in the estate, if they do, but of which the administrator or the executor is aware of. Creditors have at least 7 months to file claims for debts for the of the decedent in the estate, and you cannot make a distribution beforehand. You'd have to make permission from the court to do that for some reason, but that's not allowed. Something needs to be done in terms of, either setting aside the money for marshaling the assets to, with a sufficient amount to pay those creditors and so forth. And no distribution should be made until the property is sold. The proceeds are, deposited in a estate account, in order to pay off potential creditors that come around, and to the extent that they're legitimate, or creditors that, have claims against the estate and mortgages and so forth. You also want to make sure that the, property has not gone into foreclosure either, because that needs to be dealt with, and the foreclosure counsel needs to be contacted, because oftentimes the client's going to want to sell the property, pay off whatever is left from the mortgage, and we don't want it thrown to a referee to make a short sale or foreclosure or other type of sale. Foreclosure sale often doesn't get a lot, and if it's sold independently, it can get a lot more. But there's also, releases of liens, possible taxes. I'm not going to talk about that in terms of the estate tax. And you have to be of a very high net worth right now to be filing estate tax returns. So I'll veer off that for right now, because it's not something that a lot of people have, at least right now. That may change. Determining whether the decedent had an interest in company as well, to determine assets, liability if they're sole owner, and so forth, and also to determine whether there was a transaction in which the decedent was owed any money at the time of the death, due to a loan or other transaction. That's equally important in conjunction with the administrator or executor's duties to marshal the assets of the estate. If there's a vehicle, determining whether there's a loan outstanding, if it's all paid, whether that can be sold, whether it's part of the, if it's not part of the will, to pay debts, or if there's like a lease, determining the procedures to return the vehicle over to the company. Also determining whether there was Medicaid, whether the deceased was, in a nursing home or receiving care at home, in which involved Medicaid, because, they might be coming around and seeking payment for that. And I guess certain counties, districts are more strict than others, or more diligent. And all this information is, relevant, of course, again, to be prepared to administer the estate, whether it involves a will or whether it involves, no will at all, and also preparing for the inventory and family tree and all that. Also, checking the will for any interim clause, and also discussing with the proponent, if there is a will, about any discussing any individuals that may raise possible objections to the will that are not named in the will, that somebody that would possibly benefit, have a benefit in the event that if the will was not probated, they would get a portion of the estate through intestacy, and have some sort of prospect of getting a greater portion of the estate. So that's where we kind of go with objections and standing, and we kind of segue into that conversation, because it does happen. I've been involved with representing objections, and also defending against objections. So they do happen, and they often happen when somebody is cut off from the will, who was a family member, and somebody who would benefit either under a prior will or through intestacy if the will was not admitted to probate. So not every person interested in an estate has standing to contest the will. We're on slide 5 related to that. And objections may only be filed by those person whose interest in the estate would be adversely affected by the admission of the will to probate. And it cites to SCPA 1410. And this relates to standing. There's all kinds of cases related to standing, even, a contingency standing, that on the basis that, if the will was not admitted to probate, there might be a greater interest in the intestate. So there's different ways that comes about, but you have to have standing, because a beneficiary who lacks standing to object to probate cannot assert objections. And it's because they are determined not to suffer any pecuniary loss. And in that event, they may challenge the eligibility of the nominated executor in order to be a paying, I don't know, or because they believe that the nominated executor does not meet the qualifications. We're not going to go over the qualifications under the SCPA related to the eligibility of executors and so forth. But I in connection with the standing to file objections to the qualification of a fiduciary, that you look to SCPA 709, which provides that any person interested in the estate may object to the grant of letters. And that was a matter of Judson, November 1st, 1995, and it's New York Law Journal 32, column 1. In connection with the objections, though, I cited to In re Hall, and that's a case that's actually in your course material. And that's cited for the proposition that any person whose interest in property or in the estate of the testator would be adversely affected by the admission of the will to probate may file objections to the probate of the will. And in finding so, they said since the appellant's interest under the will was identical to that in intestacy, the pecuniary interest of that appellant was not adversely affected by the will, and thus there was no standing. I also cite to the case In re Will of Ayachar, which was a 2015 case in the Surrogates Court, in which I believe they did find standing, and that should be, that case is actually in your course material, or should be in your course material. There's also under the EPTL, sometimes, standing comes up to, issues or disputes related to afterborn children versus non-marital children and so forth. And there's case law related to that. So it can come up in different ways. So the objections, in getting down to those objections, as the most typical objections are, that the will was not properly executed. There's no due execution. The statutory formalities were not met for the due execution of the will, or it's based upon lack of capacity of the testator, undue influence, fraud, or duress. And sometimes there's forgery as well, even though I think that might be less common, at least to my knowledge. I don't think I've even had a case where somebody said that a will was forged. But in all situations, I've never seen just one objection asserted, because many of them are coupled with others, other objections. Undue influences, is often coupled with fraud, duress, and lack of capacity. There's some overlap there, and there's also the issue of confidential relationships, which creates an inference, and we'll discuss that too. But in terms of the statutory formalities, the burden of proof is on the proponent of the will in that case, not the objectant. And the reason for it is the proponent is the person who is actually trying to admit the will to probate. The proponent of a will offered for probate has the burden that the instrument was properly executed. And when you look at the execution requirements, you look to EPTL 3-2.1. and it must meet those requirements. The supervision of an attorney, and there's 2 points I wanted to make here. First of all, the supervision of an attorney gives rise to an inference of due execution. And there's case law for that proposition. Matters of Hedges is one, Second Department 1984 case. And also there's the second proposition, if the self-proving affidavit and attestation clause by the 2 witnesses accompanies the will, this will also give rise to a presumption that the statutory requirements have been met, because those statutory requirements are listed in the attestation clause and the self-proving affidavit. So unless you can overcome them, that will be very difficult. And I think, you know, the statutory formalities, you look at the will, and unless there's, you know, it's something that's often not, sometimes this particular objection is not raised because they just obviously are met, and the inferences, you know, you can't overcome them, because once those inferences are raised, then, you know, there would have to be information, evidence that would show that, you know, somehow they weren't. And I cite to matter of Farrell, but that's not in your course material. Not all cases are in your course material, but that was a Second Department 2011 case for the attestation clause and the standard that I just referred to related to inferences. The next to going is we start to get into more depth here with the objection related to lack of capacity and undue influence and so forth. And the burden of the objection is first on the proponent of the will, and it's often coupled with maybe a statutory formalities objection and other objections related to the a claim that the decedent lacked capacity, and as a result, they were more susceptible to undue influence, fraud, and so forth. That's often coupled with it. But there's a presumption of competency, and I think most of us know that you know that a will requires less mental capacity than for any other instrument, such as a contract, a deed, and so forth. And the presumption of competency and the difficulty of showing that the testator did not have competency at the time of execution of the will, not before, not after, but the time of the execution of that instrument, which purports to be the last will and testament of the testator, is paramount. If they had competency at the time of due execution of the will, even if they didn't before or after, and there's a showing that they didn't before or after, is, you know, it's not important. I cite to the case of In re Gilmore. It's a 2013 surrogates court case, and it raised a lot of the objections that I'm going to be discussing today, and included the standards, and it's a good case to read. So that's in your course materials. But the proponents, in that case, the proponent's motion for summary judgment dismissing all of the objections was granted. One of them was based upon proving testamentary capacity, because that had been raised in that case, as well as other undue influence and other objections. And that case stands for the proposition that it states, from an overall perspective of testamentary capacity, it is essential that the testator understand in a general way the scope and meaning of the provisions of his will, the nature and condition of his property, and his relation to the persons who ordinarily would be the objects of his bounty. That would mean people that he would ordinarily be deemed to want to benefit. The testator is not required to have precise knowledge of each and every asset verbatim by any means, and can, you know, just understand the plan and the consequences and effect of the will and who he wants to benefit. That's the important thing. And that's when conducting a proper, you know, execution ceremony of a will comes into play, to make sure that the testator is asked whether they read the will, whether they declare this to be their last will and testament, Do they understand who they want to benefit in the will, nature of the property, and so forth. And that's set forth kind of in that statute that we cited to before under the EPTL, and following that is helpful on both ends, whether you're representing somebody who's a proponent, an objectant, or you're estate planning with a client and you're conducting a will execution ceremony. I also cited to Crawford versus Smith. Now that has nothing to do with the admission of a will for probate. It does have to do with the deed instead. And again, we go back to a will requires less mental capacity than any other instrument, including the deed. But what I found interesting is it's Second Department 2023 case, and the court it touches upon the same subject matter. In that case, it was asserted that plaintiff claimed conveyance by deed of real property was procured by fraud and undue influence, and there was that the transfer was under a lack of capacity. He didn't have the capacity for the transfer. And I cite this just for the proposition of what I've seen clients ask me so many times during consultations related to Alzheimer's and other sort of diseases that you would think affect the mind. And the court cited case law for the proposition in that case, Crawford versus Smith, that a person suffering from a disease such as Alzheimer's is not presumed incompetent and may execute a valid deed, and that it would require to show that because of the affliction, the person was incompetent at the time of the transaction, at the time of executing the deed, just like here when you have to show incapacity at the time of execution of the will. And that's why I cited the two there. And in that case, the plaintiff had failed to establish that the decedent was mentally incompetent at the time the deed was executed. And also, there are instances too, and this comes to really factual circumstances regarding certain diseases, Alzheimer's or any other disease. This happened a long time ago. I represented a client who claimed that her son's will was the subject of lack of capacity. He didn't have the capacity to enter into the will or a deed that he had transferred property to. And she also claimed fraud, and he was the subject of fraud and undue influence. So the instrument, the will, was the product of undue influence and fraud, and he just lacked capacity. And on the issue of lack of capacity, we had to make a showing to the court because we wanted medical records, and at first the surrogates court denied. But then we made an application with, relevant facts related to the disease and how it had progressed, to raise an issue that the surrogate took a second look at it and granted limited right to receive certain medical records that we had requested for our review. And ultimately, we showed that even though the disease does not necessarily affect somebody's capacity, in this instance, it could have, because it spread everywhere, including to the person's brain, and it was not understood unless we looked at medical records about the individual's capacity, whether the individual had capacity at the time he signed the will. That was the limited scope. And so once we got those medical records through authorizations that were provided by the proponent of the will, as well as I think by subpoena, as I recollect, we took a look at them. And, even though this person was very sick, and at some point his disease had spread to his mind and affected his ability to communicate and his capacity, and he could not function in a mental capacity or physical capacity. At the time that he executed the will, he did have capacity. This treatment and so forth had not affected him that much until later on. And so therefore, those objections went away with good reason. The next objections is the undue influence, fraud, and duress, and we'll go through those. The burden of proof for these is all going to be on the party trying to set aside the transfer to the beneficiary at this point. And that burden is no longer on the proponent of the will. So as a starting point, a transfer, whether it be by will or gift during life, must reflect the issues of the testator, or in the event of a gift, it's the donor. And if the transfer reflects the intent of the other, that's when you come into an objection based upon undue influence. Because it can be set aside where it's shown that the beneficiary unduly influenced the transfer, and that this alleged influence not only occurred, but it destroyed the transfer's judgment. And there must be a first showing that, first of all, the beneficiary had a motive and an opportunity to exercise undue influence. Those showings are really simple. Motive and opportunity, they're usually always there. Those are really easy and not difficult to show. But what's difficult to show is the actual exercise of the undue influence by the beneficiary. That's the most difficult element, because there's several factors. It's often taken from circumstantial evidence because there's no one around. You know, when there's undue influence really being practiced, oftentimes the decedent was placed into isolation from his family members, his friends, and so forth. And there's other variables that come into play. Undue influence is not exercised in front of people, but it requires a lot of digging. And again, I cited to In re Gilmore, which stands for the proposition for the standard of showing undue influence, what you need to prove. And that's the objectant must show the existence and exertion of an influence, the effective operation of such influence, such as to subvert the mind of the testator at the time of the execution of the will, and the execution of a will that, but for the undue influence, would never have been executed to begin with. It was contrary to what somebody would ordinarily consider to be the will that testator would have executed, and to, you know, against, contrary to the parties that, you know, you would expect that he would want to be the natural objects of his bounty or her bounty. So without the showing that undue influence was actually exerted upon the decedent, there's mere speculation that opportunity and motive to exert such influence existed is insufficient. This is really difficult to show. And I do, you know, consult with clients that sometimes feel that somebody, hey, you know, they were always around him or her and so forth. And yes, motive and opportunity can be said for anybody, including for family members and so forth, and people outside family members that are good friends. But you have to show the influence was actually exerted. So I don't know if we want to pause for the course code at this time, Taylor.
Yeah, we'll actually take a minute. On the screen, you see the first course code. I'm going to read it out loud for everybody. It's going to be 479368. Again, that's 479368. And I'll leave that up on the screen for a moment for everybody to copy down.
Okay. Am I okay to go, Taylor, or do you want me to wait a minute?
We should be good. I think everybody should have copied it down by now.
Okay. So there's a variety of factors that must be looked into in relation to undue influence and so forth. But, you know, the overall objective is to show that the will was the product of a persistent, even subtle suggestion imposed upon somebody of a weaker mind. And it was further exploited by a relationship of trust and confidence. So what is that? You know, there's the issues of confidential relationships that come up with undue influence on many occasions. And this is where a beneficiary is in a confidential relationship with the transferor and the burden of proof does not shift, it, by the way, but it may give rise to an inference of undue influence. And if that occurs, the beneficiary of that property has to explain the circumstances. So the party seeking to provide undue influence must present evidence to show that the decedent was dependent upon the beneficiary, and that person exerted dominance or control over him or her. And I cited to the estate of Nealon, which was a third department 2013 case. That's not in your materials. There was a lot of case law here. If you want to ask me for it afterwards, that's perfectly fine. But the pattern jury instructions define attorney-client, guardian and ward, and trustee as confidential as a matter of law. And other relationships, such as nursing home operators, patient, minister, and a penitent, and a physician-patient client, physician-patient-client relationship are also considered confidential as a matter of law. So there's others that are not, but they may be deemed confidential. And one of them, and I've seen this happen before, is the home care attendant or the financial advisor. That could be deemed confidential. And in Ray Neenan, which is in your material, Second Department 2006, a beneficiary who acted as the testator's accountant and assisted with the testator's finances was deemed to be in such a relationship, a confidential relationship, as a matter of law. But inherent in those relationships, whatever it is a duty of trust and loyalty. It goes beyond friendship. It goes to the fact that the transferor becomes dependent, solely dependent oftentimes, on the alleged undue influencer. And an inference may be overcome by proof of the decedent's intent and other factors. But if there is an inference and there's a confidential relationship, the beneficiary has to explain the circumstances of the transfer to show that it's fair and free of undue influence. Sometimes there's a question, really a fact, related to this issue. But one of those factors, or a couple of those factors that could exist, are a marked change in the testamentary plan, especially if there was estate planning documents that suddenly veered off and were completely contrary to the estate planning that was conducted before. Advanced aged, impaired mental capacity, and lack of mental capacity that comes up, weakened physical condition, because that goes to the dependents, the isolation of the beneficiary, and active involvement in trying the beneficiary trying to exercise that isolation is often seen, and then the beneficiary is normally involved in the estate planning or managing the financial affairs, and the absence of independent, advice. The beneficiary is shown to really, be involved with a lot of things: the preparation, execution of the transfer documents, maybe selecting the attorney draftsman, meetings with the decedent and the attorney draftsman for the estate planning and so forth. But the beneficiary must have been shown to overwhelm and to have manipulated the decedent, overcoming, his or her volition to advance the interests of the beneficiary. And in Ray Neenan, the decedent was survived by her nieces and nephews as distributees, and decedent disposed of the estate, one half to a niece and one half to the niece's son, which was the grandnephew. And there was proof that the grandnephew acted as the decedent's accountant and assisted with her finances. And there was an objection raised of undue influence. He also selected the attorney drafter and was directly involved in the preparation of the will that was being propounded. The surrogate charged the jury that they were to make a preliminary determination as to the issue of fact, whether a confidential relationship existed, and the jury ended up rendering a verdict in favor of the proponent of the will, but the second department reversed. It was on the basis the surrogate court erred by failing to instruct the jury that there was an inference of undue influence, and that the burden should have been on the grandnephew to explain the circumstances that led to all of these bequests to him. There's also Prieval versus Urbaniak, which is a Fourth Department 2009 case. I thought that I had that in the course materials. It's not, and I'm sorry about that, but I can get that to you if you want. In Preavial, the personal representative sought to set aside transfers on the ground of undue influence because the decedent designated a priest as a beneficiary of a brokerage account, joint tenant on a certificate of deposit, and a beneficiary under the will. But the priest claimed, no, I wasn't the priest, and the decedent was not the penitent. She was my friend. So the surrogate applied the confidential relationship as a matter of law charge. And therefore, the priest was required to offer evidence to explain the creation of the accounts and the circumstances behind the estate planning and those assets benefiting him. However, the Fourth Department set aside the verdict. First, there was no requisite showing that a confidential relationship existed for the charge as a matter of law because the evidence was conflicting at the end of the day. Yet the surrogate erred in charging that a confidential relationship existed as a matter of law already. In Zarinsky, which is in your material, the proponent and attorney and a co-trustee with the decedents of trust established for her benefit was in a confidential relationship. They selected the attorney who drafted the will, they attended meetings and so forth, or the first meeting, at least with the attorney draftsman, but he was also the decedent's son. And on these facts, the Second Department affirmed the dismissal of the objections to probate because it held the fact that the proponent may have been in a confidential relationship with the decedent is counterbalanced in this case by the closeness of the family, and no inference of undue influence arose in those circumstances. And that's the thing about undue influence. A testator can have a friend that they want to benefit based upon their kindness. That's not undue influence. Undue influence is something else that we discussed. Duress. Duress is different from undue influence. Undue influence is mind games. It's mind control. It's moral coercion. But duress is threats of violence, insecurity. In a state of Rosasco, the objections established a prima facie case for duress. In fact, it was established that the proponent of the will had committed several wrongful acts consisting of violence toward the decedent, threats of repeated violence, inducing fear, and also inducing the fear that the decedent made a new will in favor of another person. Not only would the proponent harm that person, but they would convert the assets for his own benefit. And this fear was deemed to be so overwhelming that it was definitely had precluded the decedent from exercising her free will and judgment in naming who she wanted to benefit under the will. Fraud is the preponderance, instead of the preponderance of the evidence for fraud, okay, the standard is higher. It's clear and convincing evidence. And this is hard to prove. It must show that the proponent knowingly made false statements to the decedent to induce him or her, and to which they relied on these false statements, and induced them to execute a will that disposed of the property in a manner contrary than it otherwise would have been disposed. And I cited to N. Ray Gilmore again, and another case in your case materials is matter of gross. Forgery is just saying that the instrument is not genuine because it was not executed by the testator, but someone else. That's difficult to prove, but somebody who would be a family member or somebody close to the decedent had seen several signatures would be able to raise that objection if they had standing. And I cited to matter of will of Fertig related to an objectant who had appealed from a decree by the surrogate which dismissed her objection because and this was reversed on appeal because she had in fact verified her objections. She had made the right assertions related to, or sufficient assertions related to why she thought that the will was a product of forgery. And, it found that the surrogate erred in, dismissing her objections and admitting the will to probate. Lastly, we have turnover proceedings, and we are starting to, of course, run out of time. Let's see how much time we have. Yeah, we have 10 minutes. So turnover proceedings are really interesting, and this cropped up in a case that I was working on recently as well. So under SCPA 2103 and SCPA 2104, they both pertain to turnover proceedings. They permit a fiduciary to compel a third party to turn over assets or, to submit to an inquiry related to information concerning those assets. SCPA 2104 involves title to property. SCPA 2103 involves a petition by the fiduciary about any property, as defined in 103, or the proceeds of property. And the fiduciary can commence turnover proceedings, and the court has jurisdiction over the respondent that's the subject of those that petition related to the turnover proceeding. If that respondent is a domiciliary, they live in New York, or they committed an act or omission in New York, or there's special circumstances sometimes requiring, the application of long-arm jurisdiction, in which the court can sometimes have, if long-arm jurisdiction does apply, the court can have jurisdiction over the respondent. So the petition is really alleging that the third-party respondent either has money, personal property, or information or proceeds from property and is withholding it from the fiduciary, and seeks the court's exercise of jurisdiction over the respondent to submit to a hearing or inquiry, or that person that they name as a respondent actually has information or knowledge regarding the property that's the subject matter of the petition, or the information that the petitioner seeks. And again, in that case, the assertion is that the respondent is not cooperating. They're failing to impart their knowledge of information concerning it, or disclosing it, who has it, who is in possession of the property. So the relief is to pray for a hearing or an inquiry be made for the attendance and examination of the respondent concerning the subject matter of the petition. And the petitioner need not allege facts that the estate actually owns the property that is the subject of the inquiry, and it can relate to things that happen both subsequent to the estate and also before the estate. And property is defined very properly, very, very, very broadly, and encompasses all interests. So it can be a useful tool when you're not gaining information from somebody to commence a turnover proceeding in certain instances. It doesn't have to be accompanied by an affidavit, but or other written evidence, but usually, petitioners like to do that to support why they need the information. But the types of property, because we're running out of time, types of property and matters that are the subject of a 2103 proceeding are like joint bank accounts, real property, property inside businesses that were owned by the decedent at the time of death, tangible personal property. It can be jewelry, items that are suddenly missing from the home, intangible personal property such as money and securities, ownership interests in, closely held corporations or other businesses, interests in other assets that were purportedly transferred during life. And the validity of certain gift transfers. And also this came up with me in a client I represented, a gift that was really a pledge, and whether that was, and how that came about, was the subject of, an inquiry. Contract rights under, certain agreements, especially, stock agreements and so forth, shareholder agreements, operating agreements, and the validity and propriety of transactions, in whatever form, including transactions that might have been made under a power of attorney while the decedent was still alive. And ownership in real estate obviously becomes, a big one. So a couple of the procedures, a court can direct or conduct an inquiry on the actual return date of the order that's issued and that is going to be served upon the respondent if the court grants the petition. However, some courts, they're probably going to permit the inquiry examination to take place on a mutually agreeable date rather than the return date. And it can be taken at the surrogate's court or at another location. The scope of the inquiry is broad because of the fiduciary's duty under law to collect and marshal the assets related to the estate. And that's why that scope of inquiry is very broad, and the court permits great latitude to a fiduciary to conduct these examinations. Evidentiary issues such as the dead man statute, they can come up, but they're not a barrier on the actual examination itself. We could go into in quite detailed length, probably take a whole day, into the application of the dead man statute. That's obviously not going to occur here, and that's for another CLE. But discovery, it's important to know that discovery is a one-way street in the inquiry stage, at least. The discovery is not going to go both ways. It's going to be directed toward the respondent. The respondent cannot obtain during the inquiry stage a discovery from the petitioner. Sometimes you'll get a motion to dismiss. They're pretty rarely granted because you need certain factual information first before anything will be granted. But the ultimate remedies can be several. One of them can be the direct delivery of property to the fiduciary. The other remedy is just really obtaining information to know who has that property in their possession and control and why, to maybe seek a further turnover proceeding against them, or to contact them related to this, and to gather facts. The other one is sometimes injunctive relief, and we're running out of time, so I don't have time to discuss those. And imposing a constructive trust as to the proceeds of any property if they are sold, or if the proceeds are held. I think that we can pause for the course code. I've run out of time for questions at this point, and I would ask that if you have any questions or you need a citation to any of the cases that might have struck you that are not in the course material, you can certainly contact me, and Taylor will be giving me the chat related to any questions. I hope that you drew something out of this presentation, and I hope you enjoyed it. I wish you the best. Have a great afternoon.
Thank you everyone again for joining today's presentation, and thank you, Carol, for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullyrinckey.com within 2 weeks to receive your certificate of attendance. I will also leave the second course code up for another minute in case anybody didn't write it down. Well, that concludes today's CLE. Thank you again for everybody joining, and I hope everyone has a good rest of their day.